So I think that because we may end up being short of time, I think that even though somebody's missing, we should start the second part of the program of this afternoon, and gave the floor to Chiara Lapi from the University of Pisa, who will raise a number of points and will then follow with our own discussion and reacting also to her remarks. So here you have the microphone.
Good afternoon, everybody, and thank you to Professor Toniatti for inviting me to this international workshop and giving me the opportunity to share some reflections with you and to make some comments on the presentations of Professor Tiruvegandam and Professor Francavilla. I would like to start saying that the issue of legal pluralism is fascinating and extremely complex at the same time. And we could say that the issue of legal pluralism is to some extent a mirror of our contemporary scenario. India is, without doubts, one of the best fields of analysis when we have to study the issue of legal pluralism. As some scholars have observed, India is the land where we can see at a maximum level the managing of diversity in action. I speak from a specific perspective. Since I deal with, in my study, in my research, with the relationships between law and religion, my perspective is a little bit narrow comparing to the perspective used by the two professors who spoke before me. Although I need to make some intrusions in other fields of research as constitutional law, comparative constitutional law, or comparative law, my corner of analysis focuses on the influence of religion on the development of the juridical institution as, for instance, family, property, inheritance, and so on. My interest of research are concentrated on Indian minorities who live here in Italy, within the boundaries of our state in Italy. And for this reason, I try to understand the complexity of the Indian legal system, the plurality, and the diversity of this subcontinent. And so, for me, but of course not only for me, the two papers of Professor Francavilla and Professor Tiruvegandam were very interesting, and especially because these papers allowed us to see this complexity in a very profound way. I think that when we reflect on legal pluralism, and also to listening to the two speakers before me, reflecting on legal pluralism implies reflecting on many concepts which are, in their turn, complex and meaningful. The concept, for instance, of minority, the concept of religion, the concept of colonization, the concept of law, of plurality, of diversity, of gender equality, of human rights, also the concept of customary rules. These all concepts have a global interest and a global meaning. In order to remind some important points underlined by the two speakers before me, I think that one of the elements which we can, or better, on which we can reflect in our debate can be the fact that it seems that the debate, the actual debate, the contemporary debate on UCC, on Uniform Civil Code, seems to be a field of a fight, of a political fight, to some extent, because it seems that some political parties, for instance, the important political party which has an important role in the contemporary India, BJP, used the importance and use the Uniform Civil Code as a point for his political campaign. And I ask myself, or better, when I listened to the presentation of Professor Tiruvegandam, I asked myself if when the Indian Constitution came into force in 1947, was there the same behavior from of political parties, in the sense that the Article 44 of the Indian Constitution represented a sort of political issue, or represented a real will, a real desire of constitutional Indian fathers. Because when some years ago I studied for the first time this formula in English, and I read this verb in the future, shall, endeavor, I imagined, but probably I made a mistake, that this article was a sort of a direction which constitutional father wanted to give to their nation, to the India, especially after the separation, which was to some extent created also by the colonization. And about this point, I would like to remind the historical point of Warren Hastings, when during the British colonization decided to apply Hindu law and Muslim law to solve the family conflicts for, of course, the Hindu law applied for the conflicts among Hindu people, and Muslim law in order to solve conflicts among Muslim people. And so during this period there was, from my point of view, but it is only a point of view, a sort of I don't know if in English I can say, but a sort of a crystallization, a sort of I can say come dire, bloccare, crystallization of petrification of these personal laws, which maybe, if the colonization was not in India, maybe these personal laws would have been another evolution. And maybe today these personal laws would be different. So I think that one point on which we can reflect, on which we can speak and reason, is the point of the history of personal laws, and so to see their origin and their evolution and their development. So I stress, I would like to stress this point, but also the point, as I said previously, about the contemporary debate and the fact that this debate seems a political debate, and okay, of course, law is often a field of political debate, but it seems only a field of political debate, and not, and it seems that there is not a real interest to assure gender equality or to create an uniformization of law in order to protect the rights of individuals and the rights of groups of individuals and the rights of minorities and so on. Then the other important point from my perspective is that is the fact that India subcontinent has a number of population, a huge number of population, and also in order to govern this huge number of population, as the Census of India of 2001 underlined, and the fact that this huge number counts many people who belong to different religions, to different languages, to different castes, to different tribes, and so on, asks the law, the fact that law has a big challenge in order to govern all this diversity. So what is the solution in order to govern this huge number of population? with these huge diversities, which we can see from many perspectives, such as language, religion, and so on. Is the solution a uniform civil code, or is the solution to maintain the personal laws as we have actually? Maybe any of these two solutions are right or are good, and we have to reflect, to think, and think again on this point. Then I think also that the role of judge, when the judge has to apply the rules contained in personal laws, as Domenico Francavilla underlined when he spoke about the definition of Hindu, which is contained in the Hindu Marriage Act of 1956. So also the judge, who is of course a human being with his or her background, judge can belong to a specific religion. If I don't make mistake, I remember that in Shabano case, where the problem concerned a Muslim woman and the right to maintain and the application of Article 125 of Criminal Code. I remember that in that case the judge was Hindu. So also this is a problem. The fact that religious laws are often applied by people, by judges who don't belong to the religion which is involved in that particular case. But this is one of the problems that we have to see, and we have to analyze, of course, when we speak about legal pluralism in India. Then the other point is the following. For instance, the Hindu Succession Amendment Act, which came into force in 2005, sanctions that women and men can inherit the same share of inherit when the head of the family dies. So that is what law says, what personal laws, what Hindu Succession Act 2005 says. But as some scholars showed, in reality, in the fact, in the daily life, this rule is not applied, because in some parts of India, and it depends also on the geographic parts of India and also of the types of families which are involved in these situations, women continue to renounce their shares of inheritance in favor of their brothers. So women renounce their shares of inheritance in favor of their brothers, so in favor of men. And so they continue to apply a customary rule, a rule of which I think women and family in general sometimes feel the compulsory nature of this rule, and so they apply this rule because they feel this compulsory nature in the shadow of the official rule sanctioned by the Hindu Succession Act 2005, which says that women and men have the same rights in inheriting parental property. So this is another complicated issue. This is another problem which makes more complex the Indian scenario, and not only, but also the scenario which concerns minorities who leave India and and settle in Europe or in Italy or in Western countries. So it is quite strange, and it is but it is quite strange, but at the same time it is fascinating and challenging, the fact that many women in India fight in order to have the equal rights on the ground of inheritance. And there were a lot of women movements who wanted this rule on the ground of inheritance, as other rules about the gender equality. But although this rule now exists in the Hindu Succession Act, in many cases, of course not in all cases, but in many cases in the practice, in the daily life, the customary rules and not the official rules is applied. So this is another point which makes the scenario more complex. Then, sorry? Okay, I go to conclusion, and I would like to come to the conclusion with a question, with some few questions which ask myself, but maybe I don't know if these questions are interested also for you, but I think that are quite important when we discuss about legal pluralism. Also reflecting on the previous papers, and I ask myself if the Indian legal pluralism that is the presence of personal laws within the Indian legal system and customary rules and so on, is a model to admire, a model to esteem or not? Does legal pluralism risk to create a separation, or it is good? Or the presence of, or are we sure that personal laws protect really the freedom of religion of individuals and of groups of individuals? Or the presence of personal laws is due to the fact that religious leaders, such as Hinduist, Muslim leaders, do not want that these personal laws are eliminated because of fear to lose their power? I don't know. I just would like to reflect with these questions. But I conclude with another question, but it is the only question. Is maybe there a Western interpretation behind my questions? Because of course I study and analyze the Indian scenario with my Western glasses, which are difficult to take off. So my point of view risk to be influenced by my Western background. Maybe the perfect solution about the Uniform Civil Code or the personal laws does not exist, and the right behavior is to wait, to analyze the case law, and to see the evolution of the system, to see the future, to see how the system will develop in the future. After all, in one of Indian states, Gujarat, I'm sorry if my pronunciation is bad, the International Kite Festival takes place every year in January in Ahmedabad. And here I would like to conclude with this game, the game of kites, but I do not want to remind the well-known kite model elaborated by Werner Mesky, and of course, no, but
you said kites, I said, oh.
no, but of course, when we say kite and India, we automatically remind Werner Mesky, and in particular, of course, all his works accommodating religious need in relation to marriage, flying kites, and navigating the state law and other forms of law. But now I would like only to say that this game, in particular the International Kite Festival in Gujarat, is, in my view, the symbol of plurality, of diversity, and also of a thing of which we are fear sometimes. I mean also of conflicts, because as you know, in the game, the winning kite is that which cuts the strings of the others. But conflicts, of course, which naturally come from diversity. And to conclude, I conclude, have the duty to govern and to manage this complex scenario.
Okay, thank you very much, Caroline. I'm sorry, we really have strict time now. Let me just make one comment. You said that your comments are those of a Westerner and that you can't take your Western glasses off, which is precisely the very meaning of our international workshop here. We must have speakers and commentators from different backgrounds, and I'm also particularly glad that also in the audience we have people with different backgrounds. So I really hope that all the comments will come out from the audience as well, precisely because this was the purpose of having an international workshop. Otherwise, we would have had an Indian workshop, but that would not help very much, I suppose. So let's take it exactly as a means of enrichment. Let me also say that I would like to give the last 15 minutes to the two speakers. I think that they do deserve a chance of giving answers or making some final comments, which means that we now have 20 minutes for raising issues. So please be fairly quick in your comments, in your questions, whatever it is. I think that we have a microphone, don't we? Thank you. And we need to use the microphone because there is a registration. So Marco Ventura is the first to take the floor.
Just a very specific question by means of clarification on the Indian legal context with regard to Muslim personal law. I hear often references to Shariat courts. Are these courts a part of a sort of parallel legal circuit? Are they a part of state personal law as ultimately adjudicated by the Indian Supreme Court? Can any of the two or of the three enlighten me on this point, please?
Now, because Professor Ventura is going to leave earlier, I think you deserve to have your answer. But I would like to add something so that we can have a joint answer. Because your comment is absolutely crucial. I would say if we look at legal pluralism, we might expect that in order to have a sort of a judicial symmetry, for every individual legal system that you apply and enforce, you have a corresponding judicial system. So you have a legal system and their own courts. And in a number of cases in Africa as well, just think of Sharia courts, as you mentioned, in Kenya, that have been very provocative of quite a fairly important debate. And this happens also very much, for instance, in Latin America, with the law of indigenous populations. There are at least 7 or 8 constitutions, and also the United Nations Declaration on the Rights of the Indigenous People, that acknowledge the right to have their own customary law enforced by customary courts. Now, normally such constitutions say that a law will establish the ways to solve conflicts. And so far, none of these laws have been adopted because it is really very difficult. So you can think that you have separate judicial system for every legal system, but then you can also think to have plurality within the state court system. Now, the issue of having a Hindu judge enforcing Muslim law has been raised already. And this is, I would say, one of the trends of the reflective judiciary, which in fact we have more and more even in the West. So that is another model. But then a third model, what about the constitution as the supreme law of the land? Will you have at some stage a final jurisdiction which is in charge of that function that doesn't exist in the common law, that we know to be the nomophylachic function, so that there is some order at some stage? So this is a very crucial issue also because it does show that the personal record of a judge does matter. Whereas, according to the tradition of the civil law, the so-called natural judge is a judge pre-established by the law. So this is one, I would say, of the short circuits of a system of enforcing personal laws. Now, in India, there is always this mixture of diversity and uniformity. Of course, there has been a strong drive, and this is another question, and then I quit. It seems to me that Nehru, or at least Nehru's approach, was of a very inclusive nationalism, which is quite understandable because it was at the very origin of building the state and building the nation. So would the enforcement of uniform constitutional values over the diversity of religious law be part of such an inclusive nationalism, or, if you like, inclusive constitutionalism? So this is really a very crucial, problematic area. So you can just give an answer to Professor Ventura, and then we can take other issues later on.
And sorry, this is where my caveat about not knowing these issues that closely comes into play. There is a Shariat Act of 1937, but I imagine, let me tie it up to the question that Professor Tonyati mentioned. So in India, we don't have a system like in Malaysia, where there's a separate court system, and then the conflict becomes what is the religious courts and the secular courts, and how they. So the Lina Joy case, which is a prominent case, which is discussed as an example, that would not happen in India. Professor Lapi also mentioned the role of the judge, and this creates peculiar problems when there is it. But in a way, as you mentioned, usually this is not seen as controversial as long the religion of the judge. So in Shabana, what was problematic was these were Hindu judges who got to interpreting the Quran. And for many Muslims this was blasphemous. But there is a longer history to it, and if you understand why. So Shabana was decided in the 80s. Earlier we had Justice Gajendra Gadkar, who was a Brahmin Sanskrit expert. And he had to decide these early cases of Hindu sects, and which required reading of Hindu religious strictures. And he said, I am trained both in the law and in the Shastras, and I am telling you as a matter of law that the interpretation these people want is not correct. So he was assuming some kind of religious authority as well, while acting as a secular judge. And then they created something called the Essential Practices Test, where secular authority makes a decision of whether something is part of the religion or not, which befuddles a lot of people because they think the whole point of this is that you don't get into disputes of that sort. But because people like Gajendra Gadkar do this in the 60s, by the time the Shabano case comes up, the judges are used to this. I mean, this is a religious matter, but we can look at scripture. We did this for the Hindus all along, no problem. We'll do this now for the Muslims, and that completely backfires. And now, talking about this, so on the face of it, judges don't, and I think maybe there's an internalization of a legal culture. This doesn't really come up except in cases like Shabano, where there were patronizing remarks made about Islam and all these others. But the Indian judiciary, while a secular institution, has always been mindful of the fact that it does not, that it has to deal with all these diversities. So there are unofficial policies. The best cataloging of this is an American political scientist, George Gadbois, who looked at all the people who served on the Indian Supreme Court from the 1950s till 1989. And then he isolates and he talked and interviewed all the judges who lived till that time. And he said there are informal policies of accommodating religious, regional, linguistic differences. There's almost always been a Muslim judge. A single judge is not enough because Muslims are almost 15% of the population. But there's been this informal rule that there will be a Muslim judge. After Shabano, I think the judiciary has also become sensitive to the things that might happen. So again, it's not done formally, but informally there is a way by which, so for instance, 5 or 6 years ago, there was a case on the constitutional validity of the Hajj subsidy, where Muslims in India get state benefits to go on the Hajj. And the case came up before the Supreme Court. A Muslim judge, Justice Aftab Alam, decided that this is unconstitutional. But I think it's interesting that if it was a Hindu judge, those questions might have been asked. But the fact that a Muslim judge does it, now I don't know what went behind it. I mean, technically speaking, the court allocates cases not on this individualized basis. It's supposed to be done, it's a computerized process, but we know the Chief Justice has discretion. And in particular cases, for instance, minority educational rights cases, the benches that are constituted will invariably have people from the minority community. If it is not, then there's some discussion about it. So it's an odd way. There is no formal rule. Nothing about judicial appointments says that there will be these kind of quotas. But perhaps pragmatically, the judges themselves have realized how much we want to hold on to this rationalistic framework. In public perception, this matters because the names of judges are revealed. And for that, I think they pragmatically try and accommodate that. There's a similar debate now about gender on the court, and is there a right for a woman judge, and how do you do it? So I think that's the way a rational formal system tries to accommodate these sort of concerns and being dealt with. So, but the short answer to your question is the kind of situations that you have in a system like Malaysia do not arise in the Indian context because you don't have a separate court system. You have a different system of administration of laws, but that works a little bit differently.
Any other?
If I just want to remark, to highlight the fact that not this is for Muslim law, also for Hindu law in India. Not everything goes to the court, so we have an official Muslim law, an official Hindu law that is administered in state secular courts, but many issues are decided both for Muslims and for Hindus through informal mechanisms. And there is actually a policy of in some part of the history of India to favor this kind of adjudicating mechanism. And I took the chance to connect the two questions because a very difficult question is in which sense Hindu law, Indian official Hindu law, Indian official Muslim law today are religious laws. This is a very complicated question because the laws, the views that may be applied in some informal Sharia courts, and there can be a problem of connection with official state court system, are different probably. So there is this transformative role of the legislation, which is quite sensitive, of the judiciary, which can be more or less sensitive, but in any event, Indian judges modify Hindu law and Muslim law, and so there is a very basic problem. In which sense these are religious laws? Is the Hindu Marriage Act religious laws? It's actually a state legislation adopted by a parliament where all kinds of religions are represented, and this is not relevant. That applies to Hindus and so following religious lines. So it's quite different.
All right. More comments? Yes, please.
Okay, probably this is much more my curiosity, but as long as they will work, I don't know if they will, about a uniform civil code, there is a very huge problem in India, which is analphabetism, illiteracy, also in adult people. And I'd like to know if, taking into consideration this civil code, they will also do something, or even they thought about it, to implement or to help this problem to be solved. Because even if there is a lot of pluralism, but I think that a code should be the, a base for the solution for the problems of a state. So it is, if they could please help me to solve it.
The problem you were talking
No, sorry. Let's collect more questions.
about. I understand the question.
Oh, okay, I'm sorry.
Literacy, the problem with literacy, what else did you identify?
No, because there are, I read on also newspapers that in India there is a high percentage of people that suffer from analphabetism, well, are not even able to read.
Yeah.
I read it. That's the. Did I answer? Okay, sorry.
Okay, more questions? Yes, please.
Sorry, my question basically concerns the relation between the structure of the judiciary and federalism. And basically, as I'm unaware of the Indian law, I was wondering whether personal law are federal law and if they are enforced by federal judges or whether there are some room for state judges. And in this case, I was wondering whether, let's say, state judges are more sensitive toward religious pluralism.
More questions or comments?
First of all, thank you all for your presentation, which were very interesting. A question for all of you. Do you think that the current religion-based acts or religion-based code reflect the India religious geography now, which was because this model of religion-based personal law was imposed by the British occupation? So it is important to understand now. If not, who is entitled to modify this act? Which role will have, for example, the representative of religious denomination? On the other spectrum, on the other side, when and if the Uniform Civil Code will be approved, what will be the relationship between this civil code, Uniform Civil Code, and personal law? Can they coexist, these two models, or are we forced to abolish all religious personal law and in order to have a uniform civil code? Thank you.
Yes, please.
Thank you. My thanks also to the speakers for their presentations. This question is to Professor Francavilla. In your presentation, you mentioned the global issue of uniformity and diversity. And I entirely agree that it is a global issue. So the question that I had was asking you to reflect upon the Indian situation, the Indian response to that global issue, and ask whether or not you think there are lessons that can be taken for other jurisdictions from that, or is addressing this question always going to be very localized, very contextualized?
More questions or comments? I have one very quick question then, if nobody else. Now, in fact, I have two. The first question is, I think we all are familiar with the text of Article 44, aren't we? The state shall endeavor. Now, my question is, would you consider that Article 44 implicitly and indirectly gives a constitutional ground for personal law system? In other words, if Article 44 sets a purpose of transformation, a purpose of transition, does it imply that as long as a uniform civil code is not adopted, the same Article 44 provides constitutional protection to personal law system? Otherwise, is there any other constitutional foundation for considering this system consistent with the Constitution? Now, this may seem a very naive question, and perhaps it is, perhaps to some extent it is formalistic, and I'm wearing my Western glasses, but still I'm curious, because it seems to me that in India, just as in many other Asian constitutions, the constitution seems more a means of protecting the existing order rather than an instrument for changing the legal order. And this might be one of the cases. And then another very naive question, but so far I couldn't understand whether there is any stated purpose to the extent that the Uniform Civil Code should replace personal laws, or would it be sort of framework in which voluntarily you may choose to have a special marriage, as you already have, or a religious marriage. So is the ultimate goal of the UCC to replace or to complement the personal law system? And I suppose perhaps that in the Law Commission this is stated, and I wonder if it is one of the so many questions of the poor questionnaire that you mentioned. Oh yes, one more.
Professor Francavilla mentioned that there is uniformity within Hindu law as it applies also to Sikhs, Buddhists and Jainists. So my question is, can't it be interpreted as legal assimilation rather than uniformity?
That's another good question. Wow. I'm glad I don't have to answer all such questions.
Should I just start with a couple?
Yes, please.
Not simple ones, but straightforward ones. So your question on federalism, India is a federal country with a unified judiciary. So there are no state courts in that sense. There is and this is not that evident by just reading the provisions, because the Constitution mentions the Supreme Court and the High Courts, and you might well think the High Courts are the final courts at the state level, but they are not. So it's a unified judiciary. The Supreme Court is the final arbiter. All decisions of the High Courts are appealable. And in fact, part of the problem of the pendency is that many of them are appealed, and a way to regulate it is to stop it at the state court level. And the Supreme Court gets judges from the High Courts, and there's a steady stream of that happening. So when you say, how do the state courts respond, and you're suggesting that they might have different preferences, I think that is true, that the judges come from different, they're all part of the sort of national judicial service, though it's not formally called that, but they become drafted as part of that. But what happens is judges from different regions have different sensibilities, and judges from some states tend to be more inclusive, some others tend to be more militant about their religious identity. And so, as I mentioned earlier, they try and mask that they just follow formal legal authority, but it's very clear that some judges have had sympathies for particular groups, and so the Hindutva movement has been supported for the last 5 decades by judges who had clearly leanings, and they will put things in the rational, bureaucratic, formal means, things which are very, very explosive, because they suggest that the Hindutva movement can sort of come in. So that's an active question. So there are clearly, judges have religious biases, which are very often reflected in judicial decisions. Not so much even in the UCC cases. So Sarla Mudgal is decided by a Sikh judge who technically is a Hindu judge, but clearly the antagonism to Islam comes out from many readers, and they sort of pointed to that the hostility is apparent. Right? So maybe he was successfully assimilated into Hinduism, though Sikhism also has an antagonistic relationship with Islam. On the question on the last part, I take your point completely. Many people have said this. The Jains have consistently argued and litigated that they are different from the Hindus, but the court has not accepted it. Likewise, for Sikhism is clearly defines itself in opposition to both Islam and mainstream Hinduism, but the fact that you, just because of one provision where they are clumsily all lumped together, that is a problem. So I think there are groups who are very, very upset about that. And in fact, Sikhs, Jains and Buddhists do not get the privileges that other religious groups do. And that's a serious problem, I think, thinking about that and going forward. Let me just go forward on some of these other things, and I'm not sure I'll be able to answer every one, but I'll try and do that. So Professor Lapi mentioned the historical point, and your question about literacy. I have to say, when we were making these cautions about Western lenses, someone like me who's had his education largely in urban India, largely in English, and then has spent time outside, is clearly also Westernized. Right? So in the Hindutva logic, I am as suspect, perhaps more so because I seem to be Hindu, and I'm not embracing it. So in some ways, you're worse than the person who at least has a different religion and doesn't accept that. So that's a good point. But one of the things to remember in that historical process, and I'll probably just read it to you, the Hastings plan, as you mentioned, and I mentioned that there were different gradations of it. So you have to remember that original personal law, as it was practiced, was largely through an oral tradition in much of the laws that existed. I mean, Islam has had codifications, and the Quran is a written text, but there was a lot of law which came through custom and through interpretation. So Hastings and Bentinck, Hastings and Jones recognized this. So if you look at the famous 1772 Hastings Declaration, I'll read out what they say. So these are these Orientalists who come to India, who see that these people have various cultures, and how do we recognize them? How do we deal with them? Now, the Rudolphs, for instance, argue that they were, of course, servants of the East India Company, but they were also sympathetic to the people that they met. So this is the language of the 1772 plan. And it says, in all suits regarding inheritance, marriage, caste, and other religious usages and institutions, the laws of the Quran with respect to the Mohammedans and those of the Shastra with respect to the Gentus, or the Hindus were called the Gentus by them, shall be invariably adhered to. So that's a good principle. So where you can, you follow the Quran or the Shastras for the Muslims and the Hindus. On all such occasions, the Maulvis or Brahmins shall respectively attend to expound the law. So they recognize that we may not know this law. We are Europeans. We don't. So where there is doubt, it will be the Brahmin or the Maulvi for the respective religion who will help us interpret it. And they shall sign the report and assist in passing the decree. Right? So this was their initial way of, we try and recognize we are in a new civilization, these people do things in a certain way, and we'll help them do it. But this is the problem of the Western rational formal mind. We believe in codification. Right? So after a while what happens is when the liberal utilitarians come later on, after Hastings and the others have gone, these people are liberal. They also have differences of opinion with the Orientalists. They think that we should be governing them with some order. They want codification, and then they get very suspicious of the Maulvis and the Pandits, who give you a case-by-case analysis. In one case they go this way, the other way they go the other way. This is clearly violative of rule of law, and we should codify these principles. Right? So when you codify what was a living, breathing body, when you dam a river, you get something else. It's no longer the river. Now you have some very nicely charted thing, but earlier it was just going off on its own. This is why some people think that what has been done, Anglo-Mohammedan law and Anglo-Hindu law, is an invention of a tradition. These were not how these bodies existed. By intervening first with good intentions, and later as it went on with not so good intentions, because then the company's mandate took over, and then eventually the empire took over, you completely changed the process by which that body existed. So Izza Hassan says, although all these countries have Muslim personal law, Islam has been marginalized in many of these countries. Because when you codify, who does the codification? The state. So after a while, the British administrators got suspicious of the indigenous experts. So they said, no, we don't believe you're engaging in corruption. Right? But that corruption is part of the system. You make all things considered judgment. In one case, in divorce, you give some property to the husband. In another, you give it to the wife because you think that merits it. Now, to a Western formal thing, that is arbitrary. But to a system where you make these judgments and you give it, that makes sense. There is some kind of all things considered judgment at play, and those bodies of law allow for that. But when you codify and put things down in concrete, it takes a very different form, and then you want to interpret it. And then who can interpret it? People who can read, and not only read, it's not just literacy, it's legal literacy. So if you're not a lawyer, as we see in all our societies now, you can't understand it. Because that language doesn't make, you are literate, you're educated, you probably have a PhD in engineering, but you cannot interpret the law. You need to go to 5 lawyers, and 5 judges have to tell you what that text means. So your question goes to, without literacy, how will these people get it? In a way, I think the most religious people are the ones who follow the faith in the non-codified sense before the modern state intervenes. And that's Hassan's argument, that in all these modern states which have personalized law, which has been codified, it is already, I won't call it Western, because many of these people are indigenous people, but it's a form of modern rationality which has intervened in that system. And who is to say then that this codified law represents the true essence of those faiths? Right? That's a very state-led, state-run sort of thing. So those people, you're right, who are functionally illiterate, but are probably much more devout than the others, they have an understanding of their faith based on, I don't know what, but who are we to say to them, no, it's not the law, you haven't understood it, and you can't sort of do it. So I think that's the difficulty when it comes to religion and law, and how do we then make assessments of, if they're not literate, can they even follow the law, right? But at least in Asia, in South Asia, most of these bodies of law, even where they are codified, large parts of it are uncodified and are still part of custom. So you anyway have to bring in different sensibilities to be able to sort of get to that. Sorry, but I hope I touched upon
that. Yes, I agree with Arun in the reply to this question about literacy. So this uncodified law and the fact that the Indian law is now a rule of professional law. So this it may be post-colonial, in a sense, in continuity with the colonial period. So the law is administered by officials who are trained and prepared to do this. By the way, if there is time, I would ask you for later if you can tell us something about the way in which personal laws, Hindu law, and the debate of the Uniform Civil Code are taught in law schools now, because I think this also is interesting. There is also linguistic problems anyway, because this law will be in English, but will also an official version in Hindi, and there can be official version in regional languages, Tamil, etc. And on the other side, I don't want that we make the Indian case too different from the Italian case, because I think that I am a jurist and I have not read, I must admit, the entire civil code, and I assume that my cousin does not know anything about the civil code. There is Italian civil code, there is always a need for some kind of mediation between this model of legal knowledge and the people.
We are in the law school, that's our mission.
This is our
Otherwise
mission.
We would be unemployed.
Yes. The other point, there is not properly a federal judiciary and state judiciary. The Supreme Court is the only properly federal courts, but it's interesting that there is there might be different precedent in application of Hindu law and Muslim law in different high courts. The higher judiciary, high courts that are at the state level, they might include different states, but let's say that the apex courts at the state level may develop different precedent about some specific issues, for instance, also in the case of the age for marriage. So in this case, the Supreme Court, as in all common law system, will have the last words, and its decision will be binding. As for the question of Francesco, it's a difficult question, but it makes me remind the problem of caste in the Indian constitution. So perhaps many intellectuals would prefer that caste or defining boundaries with Hindus, etc., will be cease to be part of the official language, because the word codify the thing, and if you have this word in constitution and in the legislation, in the title of the legislation, you make these boundaries more real than they are in reality. I think that what in general, I'm interested to Indian law generally, also other parts of Indian law. I think that in general what happens in India may be significant, speaking legally, for other parts of the world. So the solution they find are not so culture specific that they cannot in some way travel. But if this is in any event a general problem of legal transparency, of circulation of legal models, perhaps just some units of these models are really accepted in other countries. So we have a pluralization of models. It was part of my title, but I have not time to say that the circulation of models actually is not maybe seen as a uniformizing, but actually in my view is a pluralization, because some unit coalesce with other units in different contexts, so you have actually a pluralization. But if a lesson could be learned in my strictly personal view, is that in some cases one can afford to be patient. So there is a style in Indian judges. You say that now judges are self-restraining, but the legislative, in many cases, did so. There is a conscious decision in some cases of not intervening in so difficult issues. So there is also very strong the idea that India has already a uniform civil code, but it is optional. In fact, I remember I asked to Mahmoud in Milan at a conference. I was very young. Can you tell me about the uniforms? Will you make a uniform civil code? And he replied, but we already have a uniform civil code. And I feel ashamed because I thought that I was not well updated. And they added, but it is optional. So the optional civil code will be the Special Marriage Act, the Child Marriage Prohibition Act, all these kind of acts that are uniformizing in this sense. And so this optional civil code, uniform civil code, will not set aside personal laws. But the idea we are debating is actually the superseding of the personal laws. So the Uniform Civil Code as a binding code which supersedes other personal.
So to not be voluntary.
I think that in this the policy is this, but they can also accept or decide perhaps of going faster in this process of Indian laws applying to all Indian citizens, but on a voluntary basis. The Special Marriage Act 1954 was conceived specifically for interreligious marriage, but it's an option which is open to all, to Hindus. So to Hindus. But actually is not used, if not by Hindus who have a strong sense of themselves being, for instance, atheists. Because Hinduism is not so strictly entrenched with a real religious life, or it is, but less than in other religion. And I think that in the Constitution, in Article 44, the idea, which is, I would dare say, quite Indian, is a kind of, don't call me an Orientalist, but a kind of a hierarchy, because they say many things are legitimate, are possible, but this is better than this. So the view emerging from the Article 44 is that it is this personal law system is legitimate in constitutional terms, but will be preferable in exceptional circumstances. There is a Sanskrit term, apadharma, the dharma of exceptional circumstances where you can derogate. But the constitutional problem is equality. So the real issue is if equality may be protected through personal law systems. The assimilation, of course, it's an assimilation. There is also a norm that I did not quote that say that wherever you find the word Hindu, that applies to Sikh, Jain, etc. But I was meaning that in this case, so you have a legal assimilation, but in this case you have a kind of reduction of the uniformization in the sense that some forms of life, some rules, Hindu's rules are generalized and extended to other Hindus, minority Hindus perhaps, and to other religions. But actually, the most interesting point, in my view, about this Hindu, Jains, Buddhist, and Sikh issue, and of course, they are Sikh in particular are not very happy. Why? If you have a personal law system, why don't you have a Christian, Jews? There are very few. There are small communities. Why don't they have also a Sikh marriage act, Jain marriage act? Because the interesting point, in my view, is there is Hinduism is very inclusive, but in some parts, some view of the of Hinduism is really all-encompassing. So you say you can be Christian, but actually you are Hindu. So this is a way of considering in some parts, only in some parts of Hinduism, that Buddhists and Jains actually are very close to Hinduism. And in fact, there are some Buddhist communities that are very similar to some Hindu communities or Jain communities. So a specific Hindu community may share more things with the Buddhist community than with others Hindu community. But there is this idea, and this is the political part of the question also, that there is of Hindutva, that Hindu values are universal values, and so they may apply to.
They call it is a state of mind, isn't it?
It's a state of mind. I had about this aspect. So this is another layer of the question. The last thing to reply to one of the points which were made by Chiara Lapi, the history of the personal law system. In fact, many scholars hold that the personal law system was created in the colonial period, as Aaron mentioned, but there is, in any event, this is a difficult issue because ancient law, pre-colonial law, also in Europe, were very much based on status and communities. So, according to some scholars, there is a continuity with the in the personal law systems with pre-colonial Hindu conceptions of law, Islamic conceptions of law, and the real problem will be not so much that you have the content of legislation or the content of this uniform civil code, But the very same fact that the state or the king in the past enters into the realm of family and other part of life that are perceived as something where the state cannot enter. So this is another point. But don't call me an Orientalist, not even in this last case, because I was a little bit simplifying, but in this sense, I always fear to be considered Orientalist.
Just a couple of things to what you had said. So you said it was a naive view, but that actually is the view of the Supreme Court right now. So this idea that 44 suggests that since it's not, and we looked at 372 earlier when you presented it. So in a Bombay High Court decision in the 50s, they took this view that personal laws are valid by a conjoint interpretation. And the Supreme Court has upheld that view consistently. So the correct legal position, which will come up in the May hearing, is how do you resolve that? Can you even look at the question of triple talaq if you hold those precedents to be true? So that's where it will come. So not naive at all. And I just want to, we're talking about the rational sort of framework of doing it. The one provision which has become very controversial also in the directive principles, and I often read this to my students and even they are sort of puzzled. So this prohibition against cow slaughter, because you're going for a secular modern system, you have to find a way by which you say only killing cows will not be allowed. How do you do that? And because you have this, and so you talked about Nehru, and Nehru was inclusive, but all this. So Article 48 makes for very interesting reading. And how do they justify doing it? And the logic is quite interesting. Article 48, the marginal heading of the provision says, organization of agriculture and animal husbandry. That's the term. It says nothing about cow slaughter. It says the state shall endeavor, again the same language, to organize agriculture and animal husbandry on modern and scientific lines, it seems uncontroversial, and shall in particular take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. So somehow, for animal husbandry along scientific lines, prevention of cow slaughter is very important. You might well ask, why doesn't this apply to chickens and to pigs and to others? But it's that. So the Nehruvian spirit, and I think this represents that entire generation, they were inclusive. That is why they agreed to this compromise of 44, because they realized after partition, Muslims in India were going to be targeted and their loyalty was going to be questioned. So the compromise, they said, is let them keep their personal law for the time being. We'll address it later. And his own attempt was, once we show as Hindus that we are for rationalizing our law and moving forward, then we will sort of come to it. So I have deep sympathy for Nehru. I think on many things he had it right. The one thing that he completely misunderstood, but that an entire generation did, not just in India but elsewhere, there was this idea that religion will fade away and we will all move to a modern, developed sort of world. We know now that that was a deep miscalculation.
Well, I'm afraid you never know.
Well, we never know, and we don't know how it will go
We
forward.
don't know the last word.
Absolutely.
Because, it's...
Yeah.
Well, thank you very much. I think it has been a very profitable, deep, and enjoyable afternoon. So thank you very much, speakers, discussants, and audience. And I hope we'll all meet together tomorrow at 9:30 with 10 minutes of flexibility as usual, but not more than 10 minutes of flexibility, because we have seen already that time is short and we need time for going deeper into our issues. So have a nice evening, and thank you also for the assistance that we had with the microphone and the registration. And I'll see you tomorrow. Have a nice evening. Bye-bye.